And away we go. Here we are. I'm excited. I've got my buddies Zach and Kenny. Poor Raphael, he's not feeling well. So he will not be joining us. We wish him a speedy recovery from whatever ails him. So today's a big day. It's been a little while since we've been live together on YouTube. We were live in person in LA, some of us. Kenny was there. But now here we are to answer your questions. And we got a lot to cover. A quick overview, we're going to talk about when a unit needs repairs, the process for that. We're going to talk about RSO and condos in LA City. We're going to touch on AB 2347, which was just signed yesterday by Newsom. And we're going to talk about the next trade show where you're going to get to come and visit us and see us live and in person, or that one will be live streamed. So it won't be. And we have a session that we're going to be doing there. So anyway, we're going to talk about that in a little bit. But first, gentlemen, how are you? Welcome. Good to see you. How you doing, Kenny?
Good seeing you guys. It's been good. Just a little busy. California's not making it any easier for landlords, so always going to be busy as long as you're in California.
That's right. And as long as you're a good attorney. Lousy attorneys aren't that busy right now. Zach, how you been?
Always great to see you. Always great to be here. Can't wait to do it.
LA Light Designs was here early and is excited. I appreciate that. Thanks for being here. We got questions coming in already from Gabe and Jaime. But first, let's talk about what Kenny and Zach are seeing in the courtrooms. Some questions. It's multi-part. So he's given a 3-day notice to pay or quit. He's past due 700. Summons 130 yesterday. San Berdue. His name is misspelled. Okay. So there's several of these guys, so hang in there. He has 5 days to file a response. He used the Tenant Power Toolkit, which is a great tool for renters to answer the unlawful detainer action, answer the summons. Got all the documents in order, including an application for the filing fee. He has them saved and ready to file. There's more. But around midnight the same day, I was served a 3-day notice to pay or vacate. Does the summons go away? So that's interesting. And he's getting two. Okay, so what do you guys think on that?
Yeah. So a couple things. Just really briefly touching on the wrong name. There is an ability for the landlord to amend the complaint. They could also do what's called conforming to proof if it goes to trial. That's codified under CCP 1173. They can basically say, well, if I prove that you're guilty of unlawful detainer, we'll just change the name conform to proof as to what I showed at trial. In regards to being served a new 3-day notice to pay rent or quit, if it's coming from the landlord, then that would absolutely give you a defense in the current unlawful detainer case that was filed against you. So if you file an answer with the court and you tell them they served a new notice, that's a waiver of the complaint that was filed against you, and you'd have to make the argument to the court that they've waived their right to pursue the unlawful detainer action, because that unlawful detainer action presumably is going to be based off of a separate notice that they had served previously. So if they ever serve you a new notice afterwards, the argument of waiver is going to come into effect.
Thanks for sharing that, Kenny. So, Gabe, another important thing is make sure you reach out to a local legal aid service in San Bernardino. Just literally Google legal aid in San Bernardino. There is help out there for renters. And then the Tenant Power Toolkit is supposed to have a link to help you connect with an attorney to help you wade through all this. So make sure you reach out. I know it can be difficult to get a hold of legal aid, but just be persistent. And the good news is you're doing your research and you already understand the process. You know you have to answer. And you can also go into the court for help typically as well. So definitely continue to use those services and hopefully you can get connect with an attorney to help you out. All right, so Jaime or Jamie, depending on how he pronounces it, or she, says that this person wants to issue a greater than 10% rent increase, and it's good. They understand that a 10% rent increase, that if you're above 10%, even by a penny, that's a 90-day notice, not a 60-day. That law changed. So the question is, Penal Code 396 prevent this person from serving the notice or just prevent the effective date landing during a state of emergency? So it's a good question. I'm going to defer to you guys. So Penal Code 396 is the anti-price gouging law that's in effect in the state of California when an emergency is declared. And currently, in a lot of Southern California, we have an emergency because of the fires that's been declared. And what it prevents is it prevents an increase in prices, including rent, of more than 10%. And what's important to understand, it isn't just for existing renters. If you have a vacancy, you also cannot theoretically increase the rent more than 10% on what you were charging that previous renter. So that's important. So, gentlemen, the question is it based on when you serve it or when it goes into effect? What are your thoughts? Could this person serve this notice, or should they wait until it expires and then serve the 90-day notice? Good question. Go ahead, Zach.
Yeah, so I'm going to say that I wouldn't. So obviously, if you could, you wouldn't want to have it either served in or expire in the state of emergency. I think of the two, so it'd be nice if you could get it totally outside the state of emergency, but we just keep seeming to have more and more emergencies these days. So I wouldn't want you to serve it in a state of emergency, because that's going to be more or less the mental requirement necessary for price gouging. If you serve this during a nice normal spring day, and then all of a sudden there's an emergency at the moment that you happen to have it go into effect, I'd be much more comfortable explaining that, saying I could never have foreseen all these fires, versus seeing all the fires and saying I'm going to raise the rent, and then having to explain why you decided to do that at the time that you did. So I'd be much more comfortable with it expiring during a state of emergency where the service was clean. But ideally, you wouldn't have either touching a state of emergency, God willing.
Well said. I appreciate that. Yeah, that's a great question. And what's interesting is how few people know about Penal Code 396. And to be fair, I haven't done a video on it, so I'm going to blame that. That's the world will know when I finally do a video, right? Because everybody watches them. So here, what I want to say, All Nighter, glad you're here, and I'm glad that KP and All Nighter know each other. It's good. People coming here and bonding. Like we should have like drinks together, maybe live. I don't know if we're allowed to do that. And then All Nighter, he always has his funny questions. Does anyone here remember a civil program called Safe Streets Now from the 90s? Now, in defense of Zach and Kenny, they were probably in diapers when this was around. So, All Nighter, I don't think they do. And he says those local programs were in Riverside and San Diego. We'll look into those. And don't let the fact that Kenny and Zach were in diapers in the 90s dissuade you from hiring them. I want you to know that these guys are crazy smart, and they are on the cutting edge of every friggin' thing that's going on out there for landlords. They know the law. They're boots on the ground. They're out there basically helping landlords right now and helping tenants as well right now. So long story short, just because they look young doesn't mean they don't know what they're doing. And you could make the argument that the fact that they're young is actually better, because I will tell you, in my experience, I've referred some folks to some, let's say, more senior eviction attorneys that didn't necessarily understand the laws as they were right now, and were maybe couldn't remember what the laws were as of right now. But anyway, that's a whole other discussion. All right, so let's get into some of my questions. So let's talk about, and this is a common question. I get phone calls on this. So let's say a unit that a tenant is occupying needs work. It could be there was a leak of some sort, there's mold, it could be something major. And we're not talking about terminating the tenancy for a substantial remodel. We're talking about keeping that renter's tenancy in place, but we have to get them out for a short time to make those repairs. So I know there's variation in different areas. I know, for example, West Hollywood has a slightly different process, but in general, how should a landlord handle this? Does the landlord need to pay for a hotel or Airbnb? Does a landlord need to also waive rent? Do they owe per diem? Do they have to pay for their food? Give me a quick overview, guys, on that. Zach, you're smiling and nodding. This is something you're good with.
Yeah, so it's going to depend. It's going to depend on where you are, but generally speaking, statewide, if you have an outstanding order to comply, Okay, so if the city has come by and said this place is uninhabitable for whatever reason, then and you want to remedy the defect, you can be required to pay relocation assistance. And that's going to depend on the length of time that they're out. If it's going to be more than 30 days or less than 30 days, you can be required to pay a per diem for them. You can be required to pay for their moving costs. If they decide that they don't want to come back, that can be upgraded to a higher amount of permanent relocation. But it's going to depend on locality. And then moving back from that, you can see that if there is no outstanding order to comply, so let's say, pipe burst, but it's not like the city told you the pipe burst, the tenant tells you the pipe burst. Now you're in a different kind of legal environment where the question isn't so much, what am I obligated to do under the law, but a different kind of consideration of how do I mitigate damages in any eventual lawsuit. So if the tenant wants to sue me, how do I protect myself from having those damages go up and up and up by moving them out, by paying for reasonable costs without giving away the farm and putting them up in the Ritz-Carlton and, yeah. So, in most jurisdictions, there isn't a lot of guidance. The basic rule is that you work with the city and the tenant to kind of come to an agreement that everybody can approve. But these things vary pretty wildly from place to place, from person to person, from month to month. So what I would say is should be your North Star is thinking about, if I got sued for defects of habitability, what would my exposure be? How can I take steps now to minimize that exposure, to limit my exposure, right? What is it that they could, if they went in front of a judge and told the judge, I had to pay for this, I had to pay for that, I had to pay for this, I had to pay for that, what would the judge give them? And then how can I go and pay for those things now so we don't have to do litigation, but without paying for just everything that they can come up with, okay? That's for where there's no order to comply. If there is an order to comply, you're in a different legal landscape and you got to go work with the city, and yeah, it's a mess. But where there is no order to comply, it's a lot more ad hoc.
So, Kenny, I'll let you add to that. One important thing I'd like to add is damage to the renter's personal property would not typically be covered by the landlord's insurance policy. And that's why it's important for renters to have a renter policy for their own personal belongings. And you don't want to end up embroiled in a lawsuit attempting to go after a landlord to replace your belongings. If you have your own policy as a renter, then you're protected, and they're crazy affordable. Lemonade.com, and they're not a sponsor or anything. I've used them personally, and I've had clients use them. They are very affordable for the policies they offer. So make sure as a renter you have that in place. And landlords will often require renters insurance. And I think that's a great idea. And at the end of the day, it's not to protect the landlord, it's to protect the renter, and just make life easier. So Kenny, did you want to add anything to that as far as repairs and putting a renter up and things like that?
Yeah, so in regards to repairs, if there's an issue with the building itself, everyone's very well aware that landlords have a duty to maintain the habitability of the unit itself. That's always going to be the responsibility of the landlord to ensure that the unit is habitable. With that in mind, I think adding on to what Zach said, I think the old adage of an ounce of prevention is worth a pound of cure kind of plays into effect here, where if you take steps early on in the situation where something does occur, you're not going to get hit with a $100,000 lawsuit down the road. So if a lot of it is going to come down to negotiation chops, reasonableness, and communication. There is no specific statute on point on this that will tell you have to pay $5 or you have to pay $10 or $100 for every square foot. But ultimately, the guiding principle is going to be that the landlord is going to be on the hook for habitability of the unit itself, and you have to make sure that whatever happens, that the tenant themselves are not harmed in a way that could be turned around into a lawsuit against you. Because if you sit there and say, well, I don't want to do this, I don't want to do that, I don't want to help with that, and then it turns out that this goes on for 3-4 months, and then the tenant is harmed because of the habitability of the unit itself. Well, now you've turned something that would have been, $500 repair, $1,000 repair, you've turned it into potentially $100,000 lawsuit or $200,000 lawsuit. So it is important that you are proactive about it, and you do take steps to either relocate the tenant temporarily to make the repairs to the unit itself, and ultimately, if you feel that the tenant is being combative and not letting you make the repairs, that is an evictable ground. So tenants also have an obligation to not mess around, because if there is an issue with the building and the tenant is restricting the landlord from being able to fulfill their duties as a landlord, that can also be an evictable ground. So there's duties and responsibilities on both sides here. The worst thing you can do on both sides is to just sit there and say, well, they're not talking to me, I don't want to do it, or they're being unreasonable, so I'm not going to do anything at all. The liability is just going to get bigger and bigger down the road.
Yeah, and that I agree with that. And the a big one is mold. Like, be proactive. If a renter says they're mold, try to get in front of it, because those can quickly snowball into much bigger issues. And I get a lot of phone calls from renters that are in those situations. And you guys would know better. Are there attorneys that will take these cases on contingency for renters to attempt to basically make piles of money off of landlords?
Absolutely. There are habitability cases that are filed continuously by many attorneys that they will look to see landlords who are not fulfilling their obligations under the state law to keep a unit in habitable condition. And if the landlord isn't keeping good records, if the landlord isn't, doing what they need to do as a landlord, you could be potentially on the hook for hundreds of thousands of dollars. Now, you may have insurance, but ultimately, why would you want to go through a lawsuit when you could have just fixed the problem earlier on?
Yeah, that's good advice. All right, moving on. So, All Nighter has given us some more insight. So, his dad ran that San Diego program, and it was successful. He wants to restart it. So, All Nighter, we'll have to have you on and talk about that program and getting it restarted. Nadia, how you doing? Good to see you. Thanks for coming out. And let's see what else we got here. So, this is an interesting one. How can someone find out who owns a property? Is it legal to hide behind an LLC management company? So I'm going to let you guys answer that as well. But as far as finding out who owns a property, most real estate agents, we have access to the title behind a property, and we can actually find it out pretty easily. And there's some creative ways to hide it, but it's more and more difficult to hide exactly who owns a property. And a Google search, like Michelle, my operations director, who's in the background making sure everything's working right, she is great at finding out who's behind LLCs. So anyway, so gentlemen, is it legal for the owner to hide behind an LLC or management company? And I would add to that, if you need somewhere to serve the owner, right? So go ahead, you guys take over. Is it legal to hide?
Yeah. So whenever the owner changes, or whenever a manager changes, the new owner is required to give you a document that lists the agent for service of process, as well as the new owner or management company. So that's Civil Code 1962. If you want to find out who owns a property, that's public record. So you can go down to the LA, and it's in Norwalk, recorder's office, to look up, or you can use electronic tools, some of which you have to pay for. But if you have access to electronic tools, they're going to let you look at title reports. You can see for a given property who's on the title. From there, hiding behind LLCs, totally legal for LLCs or other entities to own a property and rent it out. You want to check that the LLC is registered to do business in the state of California. So you can go on the California Secretary of State business search, look up any LLCs. They'll let you look up LLCs, corporations, limited partnerships, but not regular partnerships. Those are basically those entities are required to be registered with the Franchise Tax Board and the California Secretary of State before they can do business in the state of California. So that's a very common issue for landlords who don't know that, who don't get registered, and are really surprised when they're not allowed to file a lawsuit, really surprised when they lose a rent case or something like that. So yeah, so I would direct you to LA County Recorder's Office in Norwalk and the online California Secretary of State business search, and as well as any title search companies if you have access.
I love that thorough answer. That's a man who has had to look up who owns a property and has had to dive in. I love it. All right, let's
Kristen,
keep
I just
going.
wanted to add on really
Oh
quick, just
yeah,
like a
sure.
funny little story is, yeah, when it comes to the government will always throw wrenches to make sure that they get what's owed to them. So,
Mhm.
a lot of people don't want to fight the IRS, they don't want to fight the franchise tax board, and one of the ways that they incentivize you to pay what you owe on your taxes is if you own a company that is FTB suspended, as in you didn't pay your taxes for that company for that year, you're not allowed to file a lawsuit. You're not allowed to participate in the court system. And if you do, you will lose the case. There have been many cases that we've seen that companies that are FTB suspended have shown up, and then 6 months, 8 months, a couple months down the road, somebody realizes they're FTB suspended. Well, you just instantly lose the case. And if it was for a case that was worth hundreds of thousands of dollars, you not paying your taxes to the government just cost you hundreds of thousands of dollars. So the government will put a lot of incentive for you to pay your taxes to make sure that you can participate in the court system. That's just one example of it. And there have been cases that have been lost over that, and attorneys didn't realize that.
I love that insight. And FTB stands for Franchise Tax Board, in case you guys are wondering. That's amazing insight. And also the IRS, if you get far enough behind on taxes, they can take your passport away as well. I don't know if you knew that, but don't get to that point. I still have my passport. I'm not talking personal experience. All right, Blue Skies, 1972. With city rent control, can I keep all of my units empty? Short answer is yes. There's nothing in Los Angeles right now that requires you to rent out your units. Some areas in California have talked about the idea of taxing vacant units and basically penalizing landlords to keep them empty. New York City, I think they do that now because there's so many sitting vacant because they'd rather keep them vacant than rent them out because they can't set the rents to new market value, which is what could happen if Prop 33 passes here. All right, so we'll talk about Prop 33 in a bit, or the Justice for Renters Act. So Maria has a good question. She posted it in my community tab. I'm not going to pull it up because it'll be too tiny for any of you to read it, so I'm going to read it. So Maria asked, can you cover those COVID laws that say landlords have to pay $10,000 moving costs, etc.? She wants to know if it's all of California, certain counties. So we're going to stop there and answer this part. And what's funny is, and not funny, haha, but it's funny, she refers to it as COVID laws. And I know why she is saying that, because COVID, they put a lot of emergency protections in place for renters. And those have all expired, but they turned into permanent renter protections for renters, and they've continued to add more to those protections. So as far as having to pay $10,000 in moving costs, that would potentially be just certain areas. So for example, LA City, they require rental assistance, and maybe I should just share this LA renter protection. Yeah, you guys go ahead and answer this while I put the renter protection notice up because it's a helpful tool. So what areas have increases in moving costs and relocation assistance?
Yeah, so you're talking about potentially relocation assistance in the event the landlord wants to do a no-fault eviction. So I don't want you to think that if the tenant doesn't pay the rent, that you're going to have to pay the tenant to move out. But if the landlord, let's say, wants to move in, or if the landlord needs to recover the property because of a government's order, right? Or if let's say the landlord wants to withdraw the property from the rental market, you can be required to pay relocation assistance. Additionally, you should know in places like LA, they can also, at LA and I believe Glendale, if you have too big of a rent increase, or if a tenant leaves in response to a rent increase, you can be required to pay relocation assistance or rescind the rent increase. So there are lots of different scenarios in which you might be required to pay relocation assistance. But I don't want you to be worried that if they're not paying the rent, if they're breaching the lease, if they're running a meth lab, or they've taken up, homemade explosive kind of course, that you're going to have to pay them to move. You don't, okay? But it's only in those kinds of scenarios where the landlord wants to move in, or they're going to move out in response to a big rent increase, or there's some kind of habitability defect and they have to be moved out for a time, okay? And so you can see here the chart, the breakdown for LA. Lots and lots and lots of local jurisdictions have these. Statewide, it's going to be just 1 month's rent, okay? But lots and lots of local jurisdictions have higher numbers. So that's places like Santa Monica, West Hollywood, Los Angeles, Long Beach, Inglewood, etc. So for your individual local area, you'll have to know what the law is. But in general, this is, for LA, most people, live in the city of LA. And here you can see the breakdown. It's a grid, so you figure out whether or not the tenant is eligible or qualified. They're qualified if they're over the age of 62, disabled, or have one or more minor children. And then you figure out which column they're in. So if they've been there for less than 3 years, they're in column A. If they've been there for more than 3 years, they're in column B, et cetera. You can figure out where on the grid they land. Then you would go and potentially put that money into an escrow account. You can use a lawyer's trust fund. There are escrow companies out there that would be given to them only when they vacate. Okay, so I don't want you to just think that you have to cut them a check. Some places do it differently, but the way that LA does it, you have an escrow account and it's only given to them when they vacate. So I don't want you to think that you're just going to cut them a check and they're going to say, haha, great, I'm going to get my new, I don't know, what can you get for $25,000? That's good.
Eggs. You can get eggs. $25,000 for eggs, I heard.
There you go. Or bet it
a
all
dozen
on a hand
eggs.
of blackjack. There you go. A dozen eggs. So they're going to go have
joke there.
they're going to go have their fun with a dozen eggs. You don't have to give it to them up front. You can put it into an escrow account and give it to them at the end. So yeah, those are some of the scenarios in which you'd have to give relocation assistance. Yeah, there you go.
All right, I'm going to step in. So, of course, I can't give tax or legal advice. The guys in ties can. They can give legal advice. I can't. But I'm going to just go ahead and run through this chart. And if you can see, look at the top of this. Do you see when it was updated? That's October 1st, 2024. I've actually gone into the future and brought this back so that you guys can see what's going to happen on October 1st. So no, this is the latest renter protections notice. And there's some interesting stuff on here. The relocation assistance chart, as if it isn't confusing enough, this actually puts together two different things. It puts together RSO properties, rent stabilized ordinance properties, and just cause ordinance properties. So that where it says 1 month's rent for a single family dwelling owned by natural persons, that is the just cause ordinance. That's not the RSO. So tenants don't get excited and say, hey, I'm going to get the maximum amount. And landlords don't get excited and say, I only have to pay 1 month's rent. You need to talk to Kenny or Zach to make sure you've chosen the correct relocation assistance. And furthermore, as if it isn't confusing enough, certain people are protected from any sort of termination, just cause termination related to owner move-in, or substantial remodel, etc. So some renters actually, you can't pay them relocation assistance to go. So anyway, and this does not apply. So this happens to be the LA City ordinance. There's a statewide ordinance that I've done a ton of videos on, AB 1482, the Tenant Protection Act. And under the Tenant Protection Act, many single-family homes and condos are exempt, which means a landlord would not have to pay any rental assistance. But if it is subject to AB 1482, they will have to pay 1 month's rent. As Zach said, again, make sure there's no local ordinance that makes you basically owe more money. One other quick thing I wanted to show, there's a lot on this notice, and this is required in LA City to go out to all renters by posting it, or any new leases or renewals. But there's an economic threshold based on the bedroom size that a tenant has to be behind it in order to move forward with an eviction for non-payment of rent. Another important thing that's on here, and this is something I talked about in my video when we talked about the LA City renter protections, economic displacement. And Zach touched on this briefly. If you raise the rent enough for an exempt unit, a house or a condo in LA City, if the renter decides you're going to move out, you're going to owe relocation assistance to that renter. What's important to understand is a lot of people say, oh, if the rent is increased more than 10%, then the tenant I'm going to have to pay rental assistance. It's an adjustable number. And I talked about this in my video. That 8.9% is the new threshold. So if a landlord in LA City increases the rent on an exempt single family home or condo more than 8.9%, that could trigger this economic displacement provision. So anyway, sorry, I just want to make sure people understand that these are all moving numbers. That's why you always need to be looking at the latest one so that you know the exact numbers for relocation assistance, economic displacement, etc. Kenny, you want to add anything to that? All that fun? I know we just ran through a ton.
No, I mean, I think the only thing that I would want to add is there's a lot of confusion about what eviction types are. I think top down level, looking down, you just have to consider whether or not you're a just cause, no fault, or at fault. The no faults, essentially, you could consider it's like, well, the landlord is evicting someone, and then you ask, is it at fault of any of the actions of the tenant? So at fault would be you didn't pay the rent, you breached the lease, you're causing a nuisance. Those would be considered at fault. And generally speaking, you're not going to be paying relocation for at faults. For no faults, where the landlord is saying, the tenant, you didn't do anything wrong, you didn't do anything, that would make me upset. Due no fault of your own, I just want to get possession of the unit back. Presume most of the time you're going to be paying relocation amounts for those kind of evictions. So, touching a little bit on what Zach said earlier, you're not going to be paying relocation amounts for tenants who are not paying the rent because those are at faults. But no faults, like if you're moving into the unit, if you're withdrawing the rental unit for the rental market, if you're doing a potential renovation, you are going to be paying relocation on those.
And this question dovetails into it. Bella, good question. What is the threshold for rent increase that would prohibit a landlord from having to pay the relocation fees? So this is specific to LA City. So if your property is outside of LA City, then as far as I know, nowhere else do they have this currently in place. Oh, Zach knows somewhere else.
Glendale.
Glendale.
It's
Okay.
70%
Okay.
Glendale.
Okay. Good. And that you have to check your local area, and things continue to change every meeting with the city council or board of supervisors. So currently, based on that notice we just looked at, if you're in LA City, if it's an 8.9% rent increase or below, then you don't have to pay relocation fees if they move out. So if you gave a 5% rental increase, they said, that's it, I'm out of here. You wouldn't owe them any relocation fees for that. If it was a 9% or an 8.99%, let's just say 9% rental increase, and they say, hey, I'm out of here within 30 days, then you owe them the relocation assistance. So that's the current threshold in LA City. See if you have it in your area as well before you give rent increases. And that 8.9% is the exact same number for the Tenant Protection Act. So they're using the same numbers that are used for figuring out the maximum rent increase under the Tenant Protection Act for covered units under the Tenant Protection Act. If you're exempt from the Tenant Protection Act, so most single family homes and condos, as of right now, as long as Prop 33 doesn't pass, if you're exempt from AB 1482, there is no limit to rent increases as long as it's not retaliatory. You can't increase it 5,000% because you don't like them. That's not going to fly. All right, so that was a good question.
And
How
just
you guys doing? Go for it, Kenny. Go.
Let's talk about this really quick. The numbers for the 8.9%, that's within a 12-month period. So don't try to be, like smart about it or sneaky about it and saying, I'm raising it 5% every 3 months. It's only 5%. They're going to tally that up and say, within this 12-month period, you gave more than an 8.9% rent increase. So, don't try to like game the system in that sense. The other thing that I wanted to point out is some people are saying, oh, 8.9, why don't I just do 9%? I like whole numbers. Who doesn't like whole numbers? The issue with that is when it comes to evictions, when it comes to unlawful detainers, they follow through with what's called strict compliance. There are many cases where people will say, well, I only asked for $2 more, I asked for $5 more, or I raised the rent 30.4% or 0.4% more than I was allowed to. The 0.4% comes out to less than $4. Why can't you just give it to me? Well, if you make that argument in court, guess what's going to happen to your lawsuit? You're going to lose. So when it comes to making sure and saying, well, it says 8.9, I'll just round it up. Don't round numbers. Don't do that. Make sure that you follow through with what the numbers say precisely and do the calculations. Because if you try to round numbers, if you try to take shortcuts, you're going to be in for a headache and it's not going to go well for you. And you may end up losing a case that otherwise would have been meritorious. It's just that you put in a number that you didn't want to do the math on and you raise it a little bit too much.
I love when you say meritorious, by the way. That's one of my favorite words that you say, Kenny. And one more important thing, based on stories you've told us in the past, gentlemen, tell your eviction attorney if you've given illegal rent increases before you get in front of the judge. They need to know that that's happened. So just be honest, and then you can fix things earlier on before you're standing in front of the judge. And also, if I could just throw that out there, and I won't name any names, and nobody here needs to acknowledge this, but do not attempt to pretend to be another person when you're moving forward with an eviction or something in court. Okay, that's good advice out there as well.
Yeah, lying to
I
the court is the fast way to lose the case. Don't ever
yeah,
lie to the court.
lies,
Don't ever lie
lies
to the
in general. I mean, what mom tells you, she's right. Like, treat others the way you want to be treated, and don't lie to people. And that's a good base for winning a case. All right, so we'll do one more of these. So, does the relocation assistance apply to a no-fault eviction that is now an unlawful detainer? This is in the city of Culver City. Depending on exactly why it became an unlawful detainer, I don't think it applies, but you guys can answer. Like, the tenant gave up their right to the relocation assistance when they did something wrong, right?
Very much unsettled. So my understanding is
Ooh.
that the TPA will allow you to go and try and get back relocation assistance. But typically speaking, I'd take a look at the escrow instructions that you gave. If you gave escrow instructions, a lot of times the escrow instructions won't say anything about what happens if there's an unlawful detainer. And it might be that you have to go and evict them. And at the end of the eviction, they go and they just take their money out of the escrow account and they're on their way. So you could potentially try to, if you have good escrow instructions, or you get a judge that's sympathetic, you could potentially try and offset holdover damages that you get. If you get awarded money at the trial for the time that they were there unlawfully, you can try and offset that against the relocation amount. But yeah, we've had people where they come in with escrow instructions and the sample instructions don't say anything about, that's my understanding, sample instructions don't say anything about what happens with that relocation assistance if the tenant doesn't vacate timely. So yeah, it's very much up in the air, and this is a real trap for the unwary. Protect yourself, get good escrow instructions, and yeah, be careful with whatchamacallit, with no fault evictions. Yeah, where the tenant doesn't leave.
Yeah, and just to add on,
And
it's gonna be
well,
like
let me
the
add up first, Kenny, before you jump in. Hire one of these guys to actually write your escrow instructions, make sure that's in there. Like, who would have known that right there other than these guys? Okay, Kenny, go.
So certain localities, we always talk about you have to know where the property is. You have to know where the property is. Certain localities like West Hollywood actually states that if the tenant's defense in an unlawful detainer action is unsuccessful, but they had a good faith reason for trying to fight it, and let's say that they lose, they're still entitled to the full amount. So
Wow.
other cities may follow through and say, yeah, even if the tenants are fighting you in the lawsuit, they have the right to fight you in the lawsuit. And even if they lose, as long as they did it in good faith, and that bar is extremely low in my opinion, but as long as they say that I had a good faith reason as to why I thought that I could win this case, and that they lose, they're still entitled. They're still entitled to the full amount of money.
That's amazing, you guys. And that's also further proof that there's no silly questions on this show. Like, something I would have thought was obvious, like, This is a great question, LA Light Design, and it shows that there's there's a deeper answer for many of these things. So thank you for that, guys. Couple more here. So Nadia, back charges and late fees added to the ledger. Wasn't notified. Told me ignore the first 2 3-day notices. Holy cow! Received a third notice of the balance that you don't owe, and the landlord refuses to give an updated ledger. So what do you think about all that and not giving an updated ledger? Thoughts on that, guys?
So you're going to want to keep good records for yourself if you feel that the landlord is doing some shady stuff with you. Um, the unlawful detainer process is extremely fast, and there's a lot of people who are not prepared for the speed in terms of how fast it goes. And at court, you need to show how and when and where you made payments and how much you actually owe. And if the notice itself overstates how much you owe, you will win the case. So you need to be the one that says, here's my records, here's what I have, here's what I owed, here's what I paid, this is it. And judges are normal people. They're people just like you and me. They're going to side with the person who has the cleanest records. They're not going to go with the person that says, "Oh, well, I told them on this day," or I don't have anything in writing. If you have something, a ledger or something that shows on this date I paid this, I got a receipt. On this day I paid this, I got a receipt. On this day I paid something, I got a receipt, and it shows a pattern, you're gonna win. So make sure that if you're gonna be fighting that 3-day notice, make sure that you have some kind of receipt that shows that that notice is wrong, and then you can go to court and show the judge that, and you'll win the case.
Love it. That actually dovetails into Jarrett Richards' question. So Jarrett's another agent in my office. He's a good dude. He actually has a service animal. We did a live stream together talking about the misconceptions around service animals. So that was an informative one. Look for that. But his question dovetails into that. What strategies do you recommend for documenting issues and effectively communicating with tenants to prevent escalation? I think what you just said about documenting, having a ledger for rent, that applies to both sides. I would say landlords should have some sort of software they're using, a reliable software, not like just an Excel spreadsheet, software that documents payments collected and things like that. The other thing I'd throw in there for renters is because I get a lot of these phone calls and they'll tell me a brief history of what's happened. And I always recommend, and actually, same thing for landlords, write everything down, put a timeline together of just the high points, especially if you're going to sit down with an attorney so that the attorney can see roughly when things happen and can say, hey, I need more information on this. This isn't relevant, etc. And then effectively communicating with tenants to prevent escalation. That goes back to what we were talking about when you have issues with mold or repairs. Like, don't let it snowball. Take care of it. Don't ignore your renters. Guys, add to that, please. Advice for landlords in particular, where maybe there's some examples you have where had the landlord just communicated effectively early on, it wouldn't have turned into a bigger issue. Any specifics you can share?
Yeah, so essentially, if you are interacting with your tenants, you need to treat it like a business. And if you ever went to a business anywhere and they said, "Oh, I don't have a record of what you told me or what you bought," or if I don't have a purchase order for, say, something I bought, imagine if Amazon never gave you a receipt or didn't have an invoice for you. Would you ever order anything from them? Or if you told them, "Hey, I never got this thing I bought and I'm supposed to get it 2 days from now, and now I don't have it," would you ever buy from them ever again? No. So, you've got to treat this like a business, and that's going to safeguard you the most. Because again, if you have records that make sense, if you have records that are clean, you're going to be fine. But you have to make sure that there's a system in place that you follow through, that you could show a court, you could show a judge and say, this is what I've always done. This is what the lease says. This is what the lease allows me to do. And then the judge will treat you like a reasonable person and say, yeah, everything you've done is fine. And the more that you can show documentation, the more that you can show that you're not just, taking things as they go, the more believable you'll be in court as well. So you really do need to have some kind of systematic structure that says, on this date, I do this, or when I receive a complaint, I do this. This is what I do when I see this. This is what happens when this happens. And without that in place, you're going to kind of be fighting things as they come, and you're going to be potentially opening yourself up to a lot of liability when you shouldn't have had it.
Yeah, All Nighter has added some good stuff. Certified mail. I'm actually a fan, depending on what it is, of registered mail, because registered mail, they don't have to sign for it, but you have a tracking number. Again, depends on what it is. And emails, but be very careful with email. Email is not for serving notices. You can use for going back and forth discussing an issue. Anything to add into that, Zach?
I like telling people, you got to do everything perfect all the time. But in reality, that real life is a lot messier and more complicated. So I want you to think about what things need to be really, really strict. And those are going to be your lease, your ledger, any kind of rent increase, any kind of notice to enter or a security deposit itemization, something like that. Areas where there's a lot of dense written law about what has to happen, I want you to be very careful and proceed, very deliberately and precisely. And then for getting a text from the tenant, hey, the stove's not working, something like that. Now you start going and you want to create a record that's going to help you in the future that shows I'm being diligent in responding, but you don't need to have the level of, I don't know how to put this. There isn't a form that you're trying to get it to conform, to get it to fit into. So I see people who give out notices that are insufficient, and no amount of paperwork or certified mailing or whatever is going to fix the problem that the underlying document that you're giving is bad. And so for those things, really, 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 either if you can't go and look at the law yourself, watch a Christian Walsh video about it, or call us, right?
Yeah,
Really
call
try
you.
and stay close to the law, because otherwise, all the good record keeping in the world isn't going to keep you safe. Okay.
Well said. I just had a renter reach out to me, and of course, I always say I can't give tax or legal advice, but she was served a 60-day notice from a landlord, and I took one look at it, and I knew it was immediately invalid. Why?
Right.
It did not have Civil Code 1946 talking about renter can reclaim abandoned property,
Abandoned
blah, blah,
property.
blah.
Right.
Personal property.
Right.
Yeah, that without that language on there was an invalid notice, and it said on the bottom April 2009 was when that notice was created. So she's going to go ahead and just wait. And if a UD is filed, if the guy does it himself, the landlord does it himself, or finds an attorney who doesn't know that, get in front of the judge and lose that one. That'll be hysterical for the landlord. Okay, we're going to do quick fire because we're running out of time. This always flies by. This is so friggin' fun. Okay, so Ariana is asking about for buyout agreements, there's a 45-day period for rescission for RSO units. And she's asking, is there a waiting period for non-RSO? So I'm going to first say the 45-day period for RSO units is for LA County RSO units. And then under LA City RSO units, it's actually a 30-day period to rescind. And I know because I've negotiated these buyout agreements. There is no waiting period. There's no rescission period for non-RSO units, but it's very important for non-RSO units that the cash for keys agreement, the buyout agreement, is first signed by the renter and then signed by the landlord. Okay, you got 1 minute to add to that. Zach, anything?
No, that's really good. That sums it up. Yeah.
Okay, thank you, sir. Yeah, I did a video on cash for keys. Good question here about from Laker Mark 2006. When doing major renovations, giving the tenant 60-day notice to vacate. Is there anything a tenant can do to dispute it, challenge whether or not the work should exceed 30 days or not? And real fast, SB 567, which I did a video on, has changed the way you have to give a notice to terminate tenancy when there's a substantial renovation involved. And the big change is that you must give permits with that notice to terminate tenancy. So, gentlemen, would there be a way for a tenant to say, "Oh, I looked at their permits. This isn't going to take 30 days." What are your thoughts?
Yeah, so the challenges are generally not going to be towards that. They're most likely going to be challenges towards the procedural elements of the case, or maybe even the good faith element behind it. So they could take a look at your permit and say, "I don't think you're going to actually do this," or "It's not going to actually go forward," or "Yeah, it's not going to be more than 30 days." But they have to show that they have the burden of proof. The tenants have the burden of proof to show that that they're not going to do it, or that this is not done in good faith. As you mentioned before, the permits are going to have to be shown or served alongside the 60-day notice. And the 60-day notice also does have some other statutory language requirements that are going to have to be in there as well.
That's right. As I tell an attorney, he's right. Yeah. You guys know your stuff. Okay, we're running out of time. RSO and a condo in LA City. So in LA City, you go into Zemus, which is their tool to look up whether a property is in LA City and whether it's subject to many things, including RSO. So condos, which were built before a certain year, will fall under the RSO. So the rent stabilization ordinance. There's two provisions to the rent stabilization ordinance. There's a just cause provision in terminating tenancies, and there's a rent increase provision. Correct me if I'm wrong. I'd like the right answer here because I always forget. And this is being recorded. Somebody asked that. This is being recorded. So when I forget, I'll just come back and watch this next time. But so condo subject to the RSO in LA City, they're subject to the just cause provisions, but not the rent increase provision. Is that correct?
Yeah, that's correct. So that's we call it the Costa-Hawkins 50-50. So basically you just keep the just cause provisions. So in LA, for example, if prior to 2019, let's say, if you had a condo, you could raise the rent as much as you wanted, but you couldn't give just a 60-day notice to terminate a month to month, right? Because you have those just cause protections. Now, pretty much everybody in LA has the just cause protections because you've got the newly passed JCO, but you have two different schedules for relocation assistance. So people who have condos typically are not able to do owner move-in with that nice 1 month rent relocation assistance. I don't know why that is. You would think that so if you have a Beverly, or not a Beverly Hills, but an LA mansion, you can qualify for 1 month rent. But if you have a condo, for some reason, LA says, "Oh, what are you, the Sultan of Brunei? You can afford to give $26,000 in relocation assistance." It's one of the weirdest, most unintuitive, counterintuitive, and frankly stupid legal loopholes. But it is what it is. So yeah, if you have a condo, you are subject to the just cause provisions of the RSO.
So it's very tough to get them out. So I help landlords sell their tenant occupied properties, and we come up with the best strategy for each property. But it is very difficult with LA City condos because of these extra layers of the RSO or being just a just cause ordinance. So, here's Laker Mark. He's saying, "Thank you guys. You helped him out with a case and went smoothly." This is great right here. Thank you so much for that. I'm telling you, that's why I like these guys. And that's why, and again, we're running out of time. I wish we had could we do like a 3-hour one of these guys? Would you be able to look at Kenny? He's scared
one where
of
we
that.
drink. Yeah, the one where we
yeah,
drink.
we need the drinks. So I put this up. We're going to be at the Rental Housing Conference on October 16th together. And this is an event that you can buy a ticket for a live stream if you can't make it, or you can actually come and see us. And for the very first time, we're going to be up on stage together. So we're going to actually do a session together where we talk about the future for landlords in California, legal shifts and survival strategies. So we're going to be up on stage. We're excited about that. And you can register to come to there and come as a landlord or a renter if you'd like. And going back to talking about best practices for landlords, would be join an apartment association so you can get the paperwork and you can get the updates and you can come see us. We go to just about every one of these. Okay, so we have 15 seconds. Kenny, why should we use California Property Law Group? What's so great about you guys? I mean, I like you, but why should anybody use you guys?
Well, we know what the law says. There's other attorneys that don't. There was another guy from a civil case that appeared in a court, and we said one word, and he got scared, and he dismissed his case.
Wait, what? That was a quick story. He dismissed his case because of you guys?
Yeah, he dismissed his case last night.
Oh my gosh. Kenny, you're a bully. I didn't know how tough you were. I'm scared of you now. I'm always picking on you. No, in all honesty, now that we're past an hour, we'll just keep going. But in all honesty, these are the guys I turn to for advice. I send all my clients to these these guys. We don't have Raphael here with us because he's under the weather, but it's an amazing group, super smart dudes. They're expanding the team, and so be patient. If you call them and they don't call right back, give them a few minutes, because I send a lot of business their way. But they're expanding the team and they're growing, and they're helping all of Southern California right now, thanks to me, because I keep trying to convince them. Eventually, we'll get you to Northern California. So, gentlemen, thank you very much. There's a lot we didn't cover in this hour. Justice for Renters Act. We're going to talk about that in the future, so you're going to have to tune into that. AB 2347, which is going to change the answer time for a renter when an unlawful detainer action is filed. But you're just going to have to come back. That's it. Or come and see us at the AAOA event as well. Thanks so much, you guys. Appreciate it. And that's it. You can go take a nap, Kenny. You look tired. You're working too hard, man. You're
Thanks for
working
having
too
us on.